Hello, everybody. It is February 9th, 2026. This is the Communication and Policy Committee. I am the chair, Kara Meeker. With me tonight are members Barb Higgins and Sarah Sadowski. I believe we'll be joined by Alex DuBois shortly. From the district tonight, we have Karen Fisher-Anderson, Superintendent Herbert, and do you like to be called Ms. Wolf? Terry Wolf.
Thank you.
Special guest. I just want to make sure.
T. Wolf.
T. Wolf.
Yes.
I love it. T. Wolf is also here with us tonight. We have a pretty streamlined agenda. We only have 2 items. Tonight we are going to be discussing Policy 812.1, Whistleblower Protection, which we first became acquainted with at the last meeting and wanted to take some time to study up before we had a robust discussion. And then we will also see tonight for the first time Policy 542, Acceptable Internet and Technology Use. This is specific to students, it looks like, and it is related to AI, a very important discussion we are all having in our personal and professional lives. You have several papers in front of you tonight, and a few different versions of Policy 812.1. So I'm actually going to welcome Alex. Come on over, Roba. I'm going to let Karen explain. It sounds like the original version of the whistleblower draft that we saw at last meeting was placed in the folder for this meeting, but Karen had actually worked on a second draft for us to review. So we'll be seeing that for the first time.
So many words.
I know. Additionally, I had done some work over the weekend on that document in the folder using track changes in the hopes that I could show you a side-by-side comparison. And for whatever reason, my personal computer is not compatible with the ODT versions of the documents, and it's saved instead of saved the track changes. So if you saw the folder today and there was another version, that was mine. Apologies. So I'll let Karen take it from here, and you can kind of run through the different versions.
Okay. The only version you really need for this evening to further our discussion is the one with the yellow highlights on it. This is the second draft. What is highlighted, what is black on the document is what was presented the first time when we first initially looked at that. And then there were some additional questions that came up, and I found some more things. So what's in yellow are the additions to the second draft. So you see that in front of you, and that's, so anything else, so if you could focus on that. And then the only other thing that's really pertinent to this presentation is the RSA that you have in front of you, 275E, the Whistleblower Protection Act, which is where most of the information that's in our policy comes from. So, how did we get here? Just a real quick summation. And Ellen asked me, Kara, I know that you had made an inquiry, and so she gave me some actual documentation. So,
yeah. So actually today, just so everybody knows, I had been going over, and I'll explain what's going on in my mind with this policy, but I really wanted to get at what was asked of Ellen when this came up.
Yep.
So I shot her an email today and said, hey, did anyone provide documentation as to what the recommendation was in terms of creating a policy around whistleblowers? And I hadn't heard back, but it sounds like she reached out to you.
yes. So I have
you
2
email?
Oh, Ellen Desmond.
Oh, right.
Yeah, our grants writer.
Right.
Because that's how this whole thing came about.
That's right. She had to answer some questions.
As a result of the
Yeah.
audit that was done,
Right.
She and Kathleen got together, and Kathleen handed me some documents and said, hey, when you have a chance, I think what we'd like to do is put together a whistleblower protection policy. And I was like, okay. So when I went to Ellen, I said, what happened at the audit? Can you be more specific? Because quite frankly, when I did a research on AI, which we'll talk about later, with all the other school districts in New Hampshire, I could not find another Whistleblower Protection Act policy. However, I did find something comparable. I used Manchester because they're similar to us in a lot of ways, size-wise. And they did have a document online, but theirs is something different. Theirs is their public concerns and complaints. And I can refer to that later. So anyway, when I saw Ellen today and she told me about the inquiry, I said, yeah, if you could provide us what it is that, it's New Hampshire ED, so I take it that's DOE, right? Or
Yeah,
is
those are
that the same?
rules, yeah.
Okay. They recommended having a whistleblower policy since we certify that we will adhere to protection for whistleblowers. So there's something called a new general assurance attestation checklist, which she provided me a copy of, and I can pass this down to you, Kara. Basically says the subrecipient, which is us, will comply with the protection for whistleblower per 41 U.S. Code 4712. And then there's also a provision in here that says, in a separate part, that the subrecipient will comply again. So these were the documents that came back to Kathleen, who signed as a senior educational official from the Department of Ed, if you'll pass those down, asking, just talking about a whistleblower protection. So I think because, and I obviously can't ask her, but I think the leap was we have to attest that we're complying. To be able to comply, we have a notice requirement, and we have to have processes and procedures in effect. And so that's why I think Kathleen said, put together a policy and let's go from there. I think if we had an employee employee manual, I might say we could put that in there to put them online. But it's applicable to contractors, staff, students, parents. So really, a policy probably is the right way to go. So that's kind of.
Can you say that one more time? What applies to all that group, that entire group?
The whistleblower protection. It pertains
In
specifically.
RSA?
No, the RSA pertains to potentially your contractors and your
employees. People who are employed by the district in some capacity.
Right, but if you want to make a disclosure, it can be a parent, it can be a student, it can be another contractor, it could be anybody basically.
And you said that is in the RSA? That's out.
That's what's under. I don't know if they talk about. I can go back and look at it in a little while, but it does pertain. It was more than just employees.
Okay.
So I think, as I said, trying to check the box. That's kind of where we got to the policy piece of it. And honestly, this was a while ago. So I went ahead and started working on it. So that brings us to our policy, the second draft that you have in front of you. And so I tried to follow our structure that we've kind of come in with and started out with the purpose. And I'll go through it all. Scope, the definition section. Last time we met, obviously only had the whistleblower and the employee. But as I was going through and looking at the statute itself and some of the language talks about the good faith report and retaliation, I went ahead and added those as definitions if that is something that you all would like. Retaliation is specifically mentioned in the RSA under 275E2 for protection of employees who report violations. So that's why I put in there. The employee definition comes from 275E1, okay? So those were the ones that I felt were important, trying to whittle them down. There were a lot more out there, but whistleblower, and that's where it is, Kara, employee, student, parent, volunteer, or contractor who reports an activity. That's where that language I was just thinking of came from. So that's where I came up with the definitions. Okay.
Yeah, that's good.
Well, so I don't know if before we dive in, are you guys okay with kind of going section by section and discussing it in that way? And also before we do deep dive, does anybody in the time that we had to study this have any general comments before we get into detail? Okay.
No, it's
All
all
right.
pretty logical.
So, and as far as the scope and the definitions, I read 275E and USC, I think 4712, which is mentioned in the documents that Ellen provided. And as far as I could tell, Karen, all of the definitions and the language and the statutes and federal rules relate to contractors and employees only. That it's not necessarily members of the public, students, or families. So I'm really thinking about it in these two buckets, right? Because there are labor protections that we need to consider. And when I tried to find the definition of whistleblower, I didn't see anything in the RSA or in the federal code per se, but I did look up Black's Law Dictionary, which is sort of the standard for legal definitions.
Yep.
And whistleblower was specific to employees that report employers for wrongdoing, right? So you want to protect them from retaliation, clearly, because they're the ones that are subject to retaliation in sort of the work environment. So as we look at definitions and we think about scope, I think we need to maybe like pull apart those two groups, right? We've got the labor protections, which is covered in 275E, which is covered in 4712 as far as contractors go. But then there's going to be a point of discussion of whether we as a group think it's necessary and helpful for us to also allow people outside of the district, people not employed by the district, to what we would consider whistleblow against the district.
Could be like a parent with a concern about a student.
Right.
Of a teacher, and if they don't want to say anything.
So
'cause then-
do we consider them
Right.
a whistleblower per the policy, or do we just consider them a parent who's reporting a concern and may have a different, the idea of retaliating against a parent may fall under, it certainly doesn't fall under the provisions of 275E,
Right.
in my opinion, because 275E basically describes the process by which somebody makes a report to the Department of Labor if they can't get a remedy within the district. I
Right.
don't think a parent or a student would be able to follow that same pathway.
Right.
So if we're going to sort of model the policy after what's in 275E, I think we may need to restrain at least some section of it to what pertains to employees, and then additionally, if we create language, what we think applies toward people.
Do we have anything that addresses this? Like I can't say them because we're in a public meeting, but I have two situations that I've been involved with in the last few months as a board member that this provision would help. Both were parents in the situation. So, and parents not willing to share something because they didn't want their child to be treated poorly by the teacher or the staff member or whatever at the school.
Right.
So it would be, I think it would be good for, yeah, but I get it. I think we need to stay in our lane with this.
Yeah.
And then, but it does bring up, what do we do for those other,
Right.
because it's.
How do we accommodate members of the community
Right.
in an appropriate way?
Right,
Knowing that we can't necessarily provide them the same
correct.
kind of process that an employee would be entitled to
Right.
under 275E and 4712. Does that make sense to everybody?
Mm-hmm.
So I'm just noting that as we move through. So for instance, whistleblower, I'm not sure where the definition came from, but I might want to consider modifying whistleblower, or at least finding a comparable definition that includes students, parents, or volunteers.
I know it's a long way out of here, but University of California, I mentioned this before, Berkeley, because I went through and I was really looking for a go-by. And under whistleblower, they do talk about staff, they talk of academic or staff, so educators and staff. And I even found, which I know we're talking, those would be employees. I also found one, and I've got to put my hands on it while y'all are talking, I'll find the source, that included board members. Because one of the biggies is unethical conduct, abuse of authority or unethical conduct. And that, not that any of our board members would ever do that, but this would be another mechanism by which if somebody in our general community had a complaint, that they thought something was being used, funds or something else, it would be another avenue. So that's why I kept it broader than just employees. Although I agree with you on the statute itself addresses mostly employees. It doesn't address employees.
Right.
So.
Right, because it's a labor protection, right?
Right.
So, and what I think really does need care, if this is the route we want to go as a committee, is to provide whistleblower pathways for members of the community. I can think of a couple of situations in my current, in our current situation in the city and politically, where someone may abuse the process, assuming that there's malfeasance. That we've had people basically say, you're hiding money, you're spending money in the wrong way, this is too expensive, and if we provided them, do they deserve, how many times can they call in with a complaint? And by this draft of the policy, whoever the compliance officer is would have to acknowledge it, do a preliminary assessment, provide notice, are they entitled to that level of investigation? And, what do we do about those kinds of concerns? Does that rise to the level, somebody that doesn't have inside information about the district and may not have all of the facts lined up, but may just see something from the outside, should they be entitled to the same investigative rigor
Right.
as a
And it also gives a process for someone to follow, right? Yeah.
And good faith is one of our definitions. We could tighten that up. Again, I tried to pull terms that I thought were really relevant here, but you're right, Kara. If somebody just doesn't like the decision, potentially it could say, hey, you all are abusing your authority. But if we put more meat on the bones, they have to show a wrongdoing occurred, a violation per se, not just you don't like the decision. So,
And I got a question just about like the definition and language in both scope and the definition of whistleblower. So as I understand it, just essentially anyone can be a whistleblower. Is there a way we could adjust the language to reflect that, to just kind of extend that to everyone? Do we want to be broader with it? Like, for example, all other stakeholders, like right after contractor there in the definition, or just a way to kind of really almost put it into the words that this applies to anyone who could be a whistleblower.
I would push back on that slightly, because I think one of the key elements of the whistleblower relationship is that there's a power imbalance. So in the scenario that Carol laid out, there isn't necessarily a power imbalance inherent in a community member's inquiry, because the district doesn't necessarily have authority over their student.
Right.
But I do think, to Barb's point, like when there is an issue of power imbalance, how we address it probably should be laid out clearly in policy. But I hear what you're saying about opening it for an all call.
Yeah.
And you're right, like, if that is what we do, we should be really intentional about it.
Yeah. Yeah. I think we just have to approach that language with care. You know,
like
the
it's
last
worth-
thing we want is for the
Yeah.
district to be inundated with
Yeah.
theories, right? Like this would need to be specific to
Right.
evidence of wrongdoing. And, I mean, I've been in different states. Some states have hotlines, right, where you can call in and be anonymous and you can put in a tip. But this current policy says we'll do our best to keep the whistleblower anonymous, but it's not guaranteed.
Right.
Is that something we also want to work with, right? Because to your point, a parent that feels that there's a power imbalance, if we need to let them know that they are not fully entitled to anonymity, do they still
Right.
want to make a report? Kind of a thing. So actually, in looking at this, we kind of laughed about it's short and sweet, and we love efficient policy. But I do think that this is something that might require more extensive language, and that creates those lanes for different avenues. Because if we're just following statute, I think this is just, employer to employee or employee to employer, malfeasance, issues of finance, and then if they can't remedy it through the district, they have that sort of Department of Labor complaint pathway.
right. Well, and that's why Manchester labeled theirs public concerns and complaints. Problem that was brought out as I was looking at it, between what Manchester is using as sort of their whistleblower and what a real whistleblower statute or could be, is that, first of all, it doesn't specifically prohibit retaliation, and that's a biggie under the whistleblower, okay? Number two, it doesn't guarantee confidentiality, and here we can't, we have to be clear that we do our best, but there are going to be some instances. And then, unfortunately, on public concerns and complaints, it's not designed for reporting illegal activity, fraud, abuse, or of authority. So as I said, it's much more narrowly tailored than, to your point, Kara, than really, they're not calling it whistleblower for a reason, because
Right.
it doesn't have the protections within it.
Right.
So, but
And I
that was the
think that's-
closest thing.
Yeah. And I think it's because, sort of anecdotally, we call a whistleblower anybody that's just sort of like making something known that is being hidden, right? Or like is exposing something. But what we're also talking about here is concerns and complaints, which I think may not fall under the definition of whistleblower. It may be its own thing. There may be protections that we should
Right.
consider providing those people who have concerns and complaints.
Right.
But they're not necessarily being pressured, let's say, to commit an illegal act by hiding the exchange of money or something like that, like an employee that would need to whistleblow on that illegal act or that act of, misuse of finances. Go ahead.
Do we have any sort of public criticism policy, whatever Manchester has, that isn't really a whistleblower? We don't have that, right?
No, the closest
So-
we come to is, the kind of the chain of command piece, and I forget the exact name of the policy that talks about, especially a parent or somebody who's upset,
Following the chain of command, yeah.
Follow the chain of command. Start with the teacher, then go to the principal, then go to the superintendent, so on and so forth. But again, really tied more to the child.
Right, so the reason for asking is my, oh my God, so many words brain thinks that what we need to do right now is focus on the situation with Ellen and what we're being asked to do and leave it at that.
Mm-hmm.
But this is a robust conversation, and maybe on our list, a few months down the road or whatever, we look at the parent community, like, let's look at what's our policy for the process? Do we have a policy if there's, retaliation fear and things like that? Like, I think it's logical to look into. But if what we're being asked to do through what Ellen's situation was, I think we need to get that squared away first. That's just me. I feel sometimes like policy is you decide to put new drapes in your living room, and then now you need a new rug, and then you got to update the wallpaper, and now the trim needs painted, and all I wanted was new drapes. And so, is that?
It does.
Yeah.
It does.
Yeah, and honestly, Barb, I was thinking the same thing.
Yeah.
That both things are valid,
Yes.
right? Like, both lanes are interesting to follow. But in terms of getting Karen and the district what they need in
Yes.
terms of compliance,
Right.
getting Ellen what she needs in terms of documentation that we are, creating a pathway for reporting whistleblower complaints. Maybe we just stick to that and then
Yep.
continue our parent, community member, student reporting another day.
Because
Yeah.
interestingly enough, if you look at that piece of paper, what did I call it? The new general assurance attestation. If you look at the language of it, Kara, I don't know who has it right now.
It's right here.
Could you read it, the part that was highlighted? Because it doesn't say a policy, it says we will adhere. What does it say? I just got nervous because once it said adhere to it, I thought, well, we got to give notice and we have to have a process.
The subrecipient will comply with the protection for whistleblowers.
Yeah, so we have to comply with the protection. Okay,
Well, I'm wondering
Okay, yeah, right.
there it is, 275E.
do we know if any of our contract language, incorporates this kind of language in it? Like if, 41 USC 4712
It's
relates to-
contractors. It's and who I looked at the U.S. code today to figure out exactly, and it's much deeper. It names specific people in government positions subject to it. And so,
Well, so
But
let me.
it
Please.
does raise the issue of, do we want subgrantees, do we want subcontractors, like, how deep do we go?
right. And potentially, if this came about in the grants area, do we want to limit it to fiscal?
I had actually been wondering that myself, because one of the concerns I have is that if we tell people this is for reporting any concerns, but this does not relieve you of the responsibility to report on abuse, for example.
Right.
And so keeping it clearly fiscal might be an idea.
Yeah, right, that's a good point.
Well, I did speak to that later on, because I think it was Kara that brought it up later, or last week, and she said, well, what about like CBA agreements, collective bargaining agreements, or other policies that might pertain? And as we get to that, there's language in here that says that does not eliminate the ability to follow that other process if you want to.
Right.
More or less just gives you another option.
Right.
So, and sometimes I'll be honest, when I get calls and people are like, help, I feel like, I've got this issue. Sometimes they think they're coming in under one lane, and I'm like, actually, the better place for you to file this is really here. So, it is just another. So,
Sorry, I'm about to have a cough attack.
My next question is a little bit
Go ahead,
also
go for it.
language related too, since the policy is called whistleblower protection. I think to really have the definition of protection, we also have to define what retaliation is as well, and who retaliation could be directed to. For example, if the whistleblower is a parent and the complaint is against a teacher, that teacher may then not retaliate against the parent per se, but retaliate against the child of the
Which was the
parent.
situation, yeah, right.
And so that was, we should I'm thinking about, I know we want to try to keep it short and concise, but we also do want to, especially if that is kind of what brought this whole policy to be created in the first place. Maybe like the definition of retaliation should include that it's who it can be directed at, and
Yep, it's a great point, Alex. And I think, retaliation isn't in 275E as a definition, but the protection clause is the district shall not harass, abuse, intimidate, discharge, threaten, or otherwise discriminate against any employee. So I'm wondering if that can be wrapped into the definition of retaliation. And I did actually bring the definition of retaliation from our harassment policy that we could model it after, which is any adverse action taken against a student or employee for making a good faith report. This is harassment, but we could modify it. Retaliation includes ostracism, threats, intimidation, harassment, coercion, or other conduct which would discourage a reasonable person from exercising a right under this policy. So we could just
Mimic
model
it,
it
yeah.
after our harassment policy definition. It's a good point. So my question to you all now is, now that we have discussed scope, do we want to table this and allow Karen the opportunity to sort of remove language that relates to anything having to do with community members, parents, students, and really just aligning the policy with what is in 275E, 4712, as it relates to, financial misconduct?
Yes.
Yeah, I think so.
The
I think,
curtains approach.
yeah.
would that
That's
also
cool.
make it, that makes it strictly inter-employee rather than classroom
And then we'll
related?
come back at another point and look at what do we need to do for the other,
Right.
yeah.
I do think it would be advisable to go as far down as subcontractors, though.
Right, who we include, so anyone in the employment or has some kind of
A financial
employment
connection.
Yeah, only because of this piece about you're not-
Stakeholders.
Yeah.
Okay.
Right, and that's, if you actually look at the 275E1 under definitions, under employee, it's actually quite
Yes.
extensive. It covers a lot of ground. And the law obviously would supersede anything in our policy. So if we just said employee means and included A, B, C, and D, and E, they all still actually exist. We just aren't
Yep.
incorporating it in the policy. So we could always also just point to this provision if we needed to.
And so under reportable concerns, do you just want to limit it then to get rid of one, and just leave gross mismanagement of or waste of district funds?
No. Personally, I'm inclined to your point earlier, keep it a broad lane.
Okay.
But do
So
other folks?
all four of those?
All four of these things can apply to just the contractor, subcontractor.
Exactly.
Yeah, I think they would all stay.
Okay, so we'll keep one.
We're
through
just
four.
limiting it to we're making who's the whistleblower much more specific than all ways of whistleblowing, quote unquote.
Right. And I mean, I'm not even sure, Karen, if we need to spell it out if we're including E2, unless we're expanding on E2, because right now, in Rome 6, protection of employees for reporting violations, it actually lists out the district shall not harass, if an employee in good faith reports or causes to be reported what the employee has reasonable cause to believe is a violation of any law or rule adopted under the laws of this state, a political subdivision of the state or the United States. So it's a very broad stroke. So we don't even really need to list these out if we're just modeling after 275E. I think this would be important if we incorporated community members, parents, and students into it, like
Okay.
non-employees. But maybe we don't need it if we're just gonna stick with the
So,
employees.
so Kara, what are you saying specifically that you'd like to see struck on that?
Just that I'm not sure we need to include reportable concerns.
Okay.
Because basically anything under the law. So everything that's listed here is a violation of federal, state, or local law, right?
And I get that, and reading this, I get it. I just wonder if Joe Public is gonna understand that. They'd have to go to the statute to see what it covers.
Well, but I mean, it's here in the policy under Rome 6 as well. So, but you like the idea of listing out examples of what
Well,
a
I-
violation of law could be?
Over to you all, but I just think if we're doing this to inform, provide notice, I think it's helpful to the reader. But that's just my,
What do we think, guys?
the other nice thing, just so you all know, last year we worked on 161.1. This kind of thing is what gets me excited. 161 is our normal, is our normal discrimination, and it's really your, what we call suspect classes, so age, disability, gender, all kinds of things, religion, the hot topics, if you will. But then we included a 161.1 because of Title IX, and it's all other forms of discrimination. So if there's discrimination against somebody for having filed a whistleblower, they have another avenue, which is 161.1. So I was kind of pleased to be able to put it in our
That is
reference
kind of
section.
exciting.
Yeah, we got it
All
right.
links up.
All right.
I was trying to think, what's a good example of another kind of discrimination? And whistleblower would be one of them.
Totally is, yeah.
So, anyway, these things keep me.
You got to get out more.
I know.
I mean, if the intended audience is, I mean, if this is going into an employee handbook, I would like to see the 4 things listed, just because I do think the average employee
Right, would know
might not
what not.
read that far. But until it's relevant to them, I don't know.
Right. All right, let's leave it in. Do you want to give Karen any other instructions before she gets after this?
Let me look at this and see if I had any other.
Oh, I did want to go over false reporting.
Yep.
We include a section, Rome 5 on page 2. A whistleblower who intentionally makes a false report of wrongdoing will be subject to disciplinary or administrative action. But we don't necessarily have anything to state who determines that a false report has been made. Who determines if a report is a false report?
Probably the superintendent, because, well, the investigating officer, the compliance officer, whoever does it, will look at that and they'll decide whether or not it's substantiated or not, based on the facts. So if it's unsubstantiated, it's kind of like a false charge, say, in a sexual assault allegation. Very, very difficult to prove, and you want to be careful. But you look at the facts, and who would decide would probably, the IO would make, the investigating officer would make a determination on that, and ultimately it would be the superintendent. Unless the complaint
do you
is
want that
against.
responsibility?
Yeah, unless the complaint's against the
I
superintendent.
think that's what exists right now.
Yeah, congratulations, you already have it. Or to the school board if it's against the superintendent, which is what we do for,
I think it would follow logical grievance process, like,
Right.
yeah.
Could we ever see a situation where we wouldn't do disciplinary or administrative action? Should it say may instead of will?
I mean, I think there's like progressive actions we take when we're working with staff or administrators around, and behavior or lack of follow through in the job or things of that nature. That we do have a progressive discipline step built into most of our CBAs that we could follow, and there could be administrative action, or we call corrective action, or I think a performance improvement plans and things of that nature are part of that. So there are these things built in already to the contracts on how we do the discipline.
And do you think that this single sentence in this policy is sufficient for?
So wrongdoing is subject to disciplinary
Determining.
action.
That's disciplinary action can be a warning. It
Right.
could be
Yep.
an improvement
Letter
plan.
in
It
the
could be
file,
a
yeah.
suspension, a temporary,
Yep.
could be a lot of different things. So I think that's a specific title for a variety of actions that could be appropriate depending on what the infraction was.
If it was a subcontractor, maybe considering whether that subcontract is an appropriate fit for
right.
our building.
Do we bar them and issue a no trespass
Yep. So
administrator?
when I read that line, that's what immediately comes to mind is I would follow the process I would follow for any other disciplinary action, regards to
Right.
the staff member.
Mm-hmm.
We, I don't know if it's necessary to put out, as outlined in the CBA, but they all have grievance processes, they all have, corrective action processes built into it.
Right.
I think I would like to see something that states that, because,
Yeah.
the determination isn't there, right? A whistleblower who intentionally makes a false report of wrongdoing, as determined by the superintendent after a
Right,
review
right,
of blah, blah,
yeah.
blah. So
Right,
that
that
way,
part's- yeah.
it's not ambiguous as to how,
Would be subject to corrective action per CBA.
yeah. And just so that, you wake up in the morning and you're like, I didn't like that report. It's a false report. You know what I mean?
Right,
Like,
right.
what's the
Right.
what's the process
It
by
keeps
which
you
a
in some
false
guardrails that
Yeah.
you can't just go off,
Yeah, my
do
first
whatever
husband
you
made that
please.
report.
Exactly. I don't like it. So yeah, I would say, just anything to add to that, just to make sure that it's clear that there are guardrails around how we determine what a false report may be. So that essentially it protects Tim.
Got it. Okay.
Thank you. Is there anything else? I noticed you upped the number of days in the review, 10 from 5 to 10.
I did it because I wanted to be consistent with our other in the district.
Yeah.
Not sexual harassment per se, if it's 415, but bullying is 10 days, with 5 days to decide whether or not you're going to do one to begin with. So you really get 15 business days, but the 5 counts towards, 5 counts out of the 10, so you actually only get 10. But that's why I did it, to be consistent.
Okay, great. All right. That's all I have, and I look forward to seeing the new policy. Does anybody have any other questions or comments before we move on?
No, thank you very much.
Great, thank you.
Okay, I shall take it back. Okay, the next issue, I'll just speak briefly, and then we're lucky because we have Terry here who really knows what's going on in the IA world and not KFA. We have currently an instruction a policy, which is 542, which talks about our acceptable internet and technology use. It's a very old policy. It was last updated, I want to say, in 2004. Yeah, acceptable internet use for students. So we looked at that, and then Terry's been part of a group. I only attended the first couple sessions, but she's worked hard with a couple of other people in the district because of AI and how big it's gotten and how fast it's taken off. And we've started with our students because we also have a staff instruction, but tonight we're just talking about our students. So we started looking at an AI instruction. We took a look at a policy, and I'll be honest, I looked at it. We had a meeting this week, Tim and Terry and I, and we thought, should we try and update our acceptable interuse policy and include AI in that? Or should we separate them? And finally, as part of our AI, when we're talking about acceptable uses and things you can do and things you can't do, we wanted to include a section on deep fakes, because that is a problem. And so ultimately we went to the superintendent and said, Tim, what do you think? How should we approach this? And so the thought process at that time was, let's update the acceptable internet use students, because it is a little broader than just AI. And then let's put together an AI policy and include deep fakes within the AI policy. So you actually will have 2 in front of you that Terry spent time on. And so with that in mind, we looked at a bunch of stuff. We looked at the New Hampshire School Board Association's policy, which I believe you have a copy of, EHAG. And Will Phillips, once again, was very thorough. It's pretty complex. And I'm sure Terry will tell you what she thinks about it, what's good, what's bad. We also included the Bedford policy on deep fakes, I believe, and then our current acceptable use. Those should be documents that you have in case we get to those in their places or pieces that you like that you think should be incorporated. So with that said, Terry, thank you for coming tonight, and over to you.
T. Wolf, let's go.
Thank you. If I could just take a minute to kind of step back from the policy a little bit, especially since Alex, I don't know if you've followed along what we're doing with AI in the district or not, and for all the people who are watching at home tonight. So it's hard to believe that we've had an AI implementation team for almost 2 years now, because it's crazy that it's been 2 years. And it's interesting, it evolves, it's evolving every day. The news is changing all the time. But our implementation team has IT people on it. It has digital learning specialists on it. It's had some classroom teachers come in and out. It has IT administrators. Tim is on it. Kim Yarlott is on it. I'm leading it. It's a huge project management. And then we talk to people. Like I met with the curriculum facilitators at the high school last week, along with Graham Crowther. So it's just a constantly evolving piece. We're looking at it. We have major pillars. Policy is everybody's highest priority. Staff is very eager for this policy. Training is a major pillar. Determining use cases and how you use AI really depends on your role. A teacher's going to use it differently than a finance person, or that Tim and I will use it. So we're looking at it by role and trying to define. Some people are very comfortable experimenting with it to figure out what works for them, and others here's some prescriptive places for you to try it.
It befuddles me completely.
Exactly, right. So I
No
would
idea.
say, here, Barb, here are 3 ways that it's going to make your life easier, and otherwise don't worry about it, right? And so we're working through all of that and assessing tools as we do that. But so the policy last year, actually the whole time, everybody felt pretty strongly on fixing the acceptable use. And really, if you look at 542, the original version, so what you have is 2 different policies. You have the current version for 542 and a recommended for 542. And then you have New Hampshire School Board's AI policy, and then a stripped down version of that. So I'll start with the acceptable use, if that's okay.
Yep.
The acceptable use is very verbose, has a lot of words, talks about CD-ROMs, pagers, diskettes. It's definitely a world of
Am I the only one
philosophy.
that knows what all those things are?
I know, we got you.
No, I got you.
And the philosophy of like a computer is a privilege, the language has just really changed. So what has been proposed is it's a complete rewrite of what this is. And as Karen mentioned, what I would really like to do, I know you're going to have feedback, is we take this feedback but also update the staff one simultaneously. But I thought I'd take that. I'm sure it's going to be parallel. We want them to be similar, except for where there's obvious differences.
So is there one that exists right now that says acceptable use staff?
Yes.
Okay.
Yes, there is another one if you on the website.
Yeah, got it.
Yep. And then so this is the proposed one, and we just tried to keep it really simple. The purpose, the scope, and what's interesting about technology today is we have hardware, and then everything is cloud-based, almost. So the definitions in some ways have become similar. I mean, simpler. We have computers, printers, 3D printers, but then everything else is on the network. And most of our network stuff is in the cloud today. It's for security, it's for backups, it's for everything. So it's a very broad definition versus, and actually we're even recommending that changing the name where it's acceptable technology use, not acceptable internet use.
Well, they're one and the same now.
That's exactly.
There's no piece of technology that doesn't connect you to the internet
Right.
anymore.
It's
Maybe
all-
a car starter, but we're
And
not.
so we sandwiched in this particular one, bullet number 3 under 2 scope, artificial intelligence fits into what the tools are. So we just tried to cover every broad type of application that we could think of: district email, learning management systems, adaptive learning platforms, content creation, assessment, artificial intelligence, and instructional hardware. And our older students do take Chromebooks home, and these policies apply to district technology even when they're not at school.
Correct. Right. Those situations have come up before, examples of bullying and
Yep,
stuff.
yep. And I think this makes, putting it in here and updating it makes it clearer compared to the CD-ROM pager one. We put in definitions because I understand definitions are always a good thing. So we put in some definitions. Had some great conversations with a digital learning specialist. After Karen gave me some feedback, I talked with them in depth the other day. And I was a little bit concerned about the idea of, this says privilege of use. You violated the policy, we're going to take away your laptop. We can't do that anymore. And so, but they're already restricting use. That's a practice that they have. So either browsers get locked down or they have tiers of managing it if there's a situation that comes up.
You don't have to take away the laptop.
Right, exactly.
meaning
Right, but
Our
the
teachers and staff.
yeah,
Okay.
but the old-fashioned
Correct. Yeah, you
idea
just can't
is
use it
that
anymore.
we're going to take your device from you, and they've already moved past that.
Right.
And that there's tiers of how they manage it.
Well, I would imagine a bell-to-bell, cell phone ban, so to speak, has minimized some of this as well, because all they can use at school is a Chromebook. I know, I get
Right.
it, that's where AI comes up in
Right.
classrooms and stuff, but.
But it has turned some kids to using their Chromebooks more because they can't be on their phone. But so teachers are now managing that, and it's just something that they're dealing with. We moved to educational purposes. Tried to keep this. This is probably one of my areas that I'm a little stuck on the most, is trying to keep it broad and flexible and keeping it as examples. We also wanted to put something positive in here, so it wasn't just punitive of what you can't do. We made it very clear that there are no expectations of privacy when you're in this.
Right.
This looks great.
What about, and we don't, maybe I'm getting over specific, I'm listing all these different things. I know a lot of type 1 diabetics now have iPhones and they use their technology to manage their insulin and all that kind of stuff. Should we put is there a health one in here? I'm just not reading it clearly.
Where would you?
Acceptable use?
Oh, absolutely.
Medically approved.
Medically approved.
Devices or
Like I have a couple kids at
applications.
track camp that, I have a no cell phone policy when you're out and about except those two, because they monitor their insulin on the app on the iPhone.
It's there's nothing to prohibit it at all,
Right.
but their phones.
Would we want to
If you're
list it though
on-
under acceptable use?
If you're on our network, well, this is district technology,
Okay. Oh, right. Got it.
right?
Got it. Okay.
But if they're on our network,
It's now
so
privacy.
the network traffic is tracked. So if anybody uses the bring your own device network, your usage on the network, which is what happens at Panera or anywhere else you go, your traffic is
Yeah.
being monitored, which is why you use a VPN. But so that communication, if they're using the wireless network, would be monitoring that. But I feel like I hope that's covered.
Yeah, no, that would be, yeah.
To,
Yeah.
to Barb's point too, with the acceptable use and being essentially being the exception to the cell phone law,
Yeah.
the student would have either an IEP or a 504
That
plan
had it in there.
that would
Yeah,
it would
that I
say
knew. I
that,
wasn't just
yeah.
sure if
Yeah.
I need to cover it again here, but I get it now.
So it's at least covered somewhere.
I know. Yeah. We rely so heavily on devices we have no control over.
Oh no, it's getting.
This big power outage makes me nervous.
And so Karen's advice was to kind of keep this a little bit clean, and then so New Hampshire School Boards Association created an artificial intelligence policy, and it really wasn't a fan of it out of the gate. It's long, it's very narrow, and it's perceptions of AI. I will want to be fair though, they did create this probably about a year ago.
Yep.
Changed so
Probably
much.
And AI has evolved, but I'm going to give you one example. Was it said evidence-based AI tools? That doesn't,
is it evidence-based?
Yeah, evidence-based AI tools doesn't really. That's not a thing, And the other thing is it talks a lot about an approval process of tools. And so we've had some pretty seriously in-depth conversations of we can't approve every single tool because they're embedding AI in tools that we
Oh,
already
can't get out of it.
use.
Right.
And so we want to make sure our overarching umbrella with this is it has to meet the data privacy policies. That's like the absolutely 100% golden rule of following that. So you have the NHSBA version for reference, but then you'll see that the one that we came up is much shorter. Just addressing artificial intelligence. I noticed I would like to pull out the word, I pulled it out everywhere else, but the word generative shouldn't even be in the title because we're looking at using some agentic AI. I mean, and that's not generative.
Correct, I didn't know what regular AI is. Now there's
Yeah,
like
don't.
It moves very fast.
It,
And
there's,
that's, it's a good idea to keep a policy broad
Right, for those reasons.
Right.
for those reasons, yeah.
right, and again,
In fact,
keeping
it's
that
changing so rapidly.
umbrella of, these are the principles that we must follow.
Well, and I would say, oftentimes we have policies where we write into the policy that it needs to be reviewed on an annual basis or every other year. For technology and AI, I would recommend adding that to the policy, just so that it's always on our list of like, hey, we're probably gonna need to look at this, a year from now, the definitions may change. What is available may change. How the kids are getting around it may change. So I would probably recommend having a annual review.
Yeah, that would make sense.
Yeah, it's in there, every March, not later than March 31st.
Oh, good.
Well, so we have an AI plan, if that's
Yeah.
if you mean the policy. So the purpose is just try to recognize the potential of AI, a very basic general statement. I kept the definitions narrow to artificial intelligence, AI literacy, because that's going to be a really strong piece for all of our students and our staff. Is AI literacy should mean, do you understand the basics of how AI works, ethical use, and kind of appropriate use? And that's just a foundational, introduction of some AI literacy, and then building some, good fluency over time. And then we put deepfake in here, and again, I'll be very interested. Bedford has a whole deepfake policy. I did bring it, but it was very prescriptive on punishment, and I know that that's not what we typically do. So I just focused on the definition here, and then later in there is a prohibited use, and that's where we specifically get after deepfakes. And so we have the use of artificial intelligence. It's kind of just, again, sort of like a broad general statement of AI tools based on grade level and learning needs. Again, interesting conversation that has evolved over the past year. The digital learning specialists just said in the past month that their perception of, they're like, a year ago, we might have used AI in the elementary schools, and they're like, we would not now. Like, we'll talk about it. What's something that's fake? But they don't want to use AI at the elementary level. And so that's just an evolution of
Pencils
thinking
and
and
crayons
learning.
are great at the elementary level.
Exactly, right.
We're
But I
working on
think
going backwards right now.
Yeah.
right, it is isn't it?
Yeah. I mean,
Yeah.
I think it's in any pendulum swing, right? Like,
Yeah.
I think.
New math, old math,
Yeah.
new math.
And also, even kids tire of content, of exposure. Like, there is a threshold at which it just becomes too much. And so what was exciting is no longer exciting. And,
Must scroll.
yeah.
It's interesting. It feels like a lot of younger people I've talked to, they're not crazy about it in some ways. I think they like playing with some of it, but there's definitely an ick factor. They feel it's sort of like they get it.
Yeah.
Okay, and
Well,
then
this is great. I mean, and thank you, Karen, for pointing out that there's as with a lot of our policies, there's the policy and the plan, and the plan is going to be way more flexible.
Right.
Having said that, though, this is detailed enough that I would probably also, I would like the report to come to committee for review to see if modifications to the policy are necessary. I think that's, because we never want those two to be incongruent.
Gotcha.
Yeah.
we
Because
did,
and even just RSA, like we have some citations to RSA, those I have a feeling will probably change as well.
and It's interesting. I have not seen anything on artificial intelligence in the legislature this year. It doesn't mean it could be there, but a lot of states are doing laws because of the mess at the federal level. And so I'm sure over time we will be citing specific RSAs. And there is nothing to cite now. This is really
Yeah.
what we've, more privacy driven and
Yeah.
safety driven.
I mean, that's interesting because that is, seems to be a priority for the legislature when it comes to like student and parent
Right.
responsibilities and privacy. So I'm surprised we don't see that more.
Right.
That was one of the areas that crossed my mind, thinking about how sensitive the legislature is to, say, parent consent around photos.
Right.
And thinking about prohibited conduct, the section Roman 6, thinking about how distributing or presenting deepfakes of an identifiable person, like if that person it does get us into difficult territory. District devices using photos of students without their consent probably should be the threshold whether or not the intent is to do harm or not. I mean, I could see a situation where you make a birthday card for your friend and it's in violation of policy, but at the same time, like, I don't know. I know we can't do anticipatory policy, but it would be an opportunity to talk to students about consent and image consent,
And I know they are talking about, there is a digital literacy curriculum and I think, so when, hopefully, if this audiovisual bill does make it over to the House and there's an opportunity for testimony, one of the distinctions that we would like to make is the difference between using video and audio for educational purposes compared to using it for like social media. Because my perception is that I think the legislature was trying to protect kids more from social media, right? Or in privacy, because I know a lot of people who don't want their child's image out on social media, and I think most people respect that. But today, our technology tools that we are using with kids to give them a modern education, they record their own audiobook.
Right.
They record, I guess kids love to hear their own voice, and are they fluent in their
do.
reading, And those are, I don't think that they probably had an understanding when they passed this legislation. Do we all of a sudden not let kids participate? And I think that the same for AI. Our intentions in the definite near term is parent consent or informing parents. So we do have a pilot planned at the high school this month, and the middle school is also looking at a pilot. They have an AI tool that they can have very locked down, like basically by assignment. So there isn't any playing around with it away from it. And so we would reach out to families, and we did this last year for a short period of time, and families were great actually about it. They called with a couple questions, and then they were good with it because this is the world that we're moving into.
Truly.
So we did ethical use, and I think these are the main pillars that a lot of people talk about: academic integrity, transparency, respect and responsibility, equity and fairness, as kind of the main pillars that we need to always be considering in AI as we move forward. And then as we move to number 6 is the prohibited content. And we've tried to just be really clear what's not allowed.
I was just trying to look it up real quick. What's the policy number for the technology used for employees or staff?
Just gave it to Barb. What is it?
You want to take it? 433.
Oh, thank you. Yeah, I just wanted to see how much the language mirrors the existing.
433, I think, was updated in 2018. So
It's a little.
it's not going to be as bad.
Right.
I was just curious because I think, just like before, at the last meeting, we were just seeing the whistleblower language for the first time, and I wanted to offer the group a chance to sort of sit and absorb the materials. So before we come back and have a robust discussion,
Yeah.
I'd like to offer the same
Thank
here.
you. Can we have like a little accountability buddy group session?
Yeah,
You can
absolutely.
explain it to
Everybody
me
check in with your friends. How you doing on that
A little
policy?
Zoom call, like what does this mean?
Yeah, so I would say let's take the opportunity to review the new policy 542, which is what we call a repeal and replace.
Yeah.
So it means that we would get rid of the old policy and bring in the new policy without having to try to integrate the language. It's much cleaner. And then we have a new policy, which will need a number.
I came up with 542.1 because I thought it was connected to it, but
do it.
if you don't like it, we can.
That's easy cheesy.
It
Oh,
just
yeah, I
helps
just
us,
figured
it
it
helps
should-
us for now.
And if somebody knew that number for the old policy, they'd have an easy time finding this
Yeah.
one.
There you go.
And then I would like to just say, everybody, also please look at policy 433,
Yeah.
which is internet use for staff, because
Yeah.
it sounds like they would like us to be making changes in parallel. Is this, I think this would still be a repeal and replace, though. even
Looking
if-
at it, it looks very similar to the
Yeah.
the
It
current
just-
542.
It looks like it
Yeah.
just changes the,
Yeah.
Okay.
From student to staff,
Staff.
yeah.
So we're gonna make the assumption, just breeze through 433 to make sure that you are noticing any differences, but understand that this is also gonna be a repeal and replace, that we'll see a draft of maybe next meeting, maybe not, at some point.
If you would like, I'd be
Yeah.
happy, or unless you want to do all the feedback and we duplicate it.
If they're similar enough, then yeah.
Okay.
I mean, I would imagine just.
I will
would
will
hope
dig
that we
in to see if
wouldn't need
there's.
to tell staff that certain things, but, maybe we do.
Oh, I think it's, the difference is the, maybe the warnings, but I'll dig
Right.
into the difference.
Okay.
Okay.
And please, it's a very busy season with budget, so if you need to do this later, that's fine too. But it would be nice to kind of move it all forward at the same time.
We would like, staff is really, I know I've said it in the past, right now, we've given staff permission to experiment and learn how to use AI, just no student data. So, but we're not saying you need to use this tool, we're encouraging, every tool has different good things and bad things, and we're encouraging them to use it, and a lot of people are. But they would like that comfort. To them, a policy is sort of like a security blanket,
backbone.
especially on this topic. So we would like to move forward.
Yeah.
So, yeah.
And I do think,
I'd be happy to come back.
I'm not saying that the full board doesn't read all of our policies when we bring them forward, but I think that they put a lot of trust in us. So I think that when we review things and finally bring it to the full board, they're like, if you negotiated it, it looks good
Right.
to us. I think this one may actually generate some interesting conversation at the full board.
Maybe we keep it out of consent agenda, which we do anyway when we have policies.
We
done.
definitely-
It's never in consent.
We
but-
do anyway, but maybe we
Yeah, make a point.
carve out some time for a fuller explanation. What typically happens is by the time it makes it to the full board, we do a first reading where we just introduce the language. Then everybody on their own time is supposed to research it, offer amendments or thoughts or concerns before second reading, and then we have that full discussion. We often don't really engage in a larger discussion because it's clean and ready to go anyway. But I do think this would generate some conversation, so maybe we embed a little presentation in there when it's time to come to the full board.
I think for such a big topic that's so different, I think that totally makes sense. So, yep, and it'll probably be completely different than what we think it might be today.
Yeah.
Awesome. Yeah.
Great. Okay. Does anybody have any further questions, concerns, comments before we close this out for the night?
Nope.
Anything? Thank you all for your hard work on
Yes,
this.
thank
It
you.
looks really clean and good, and we'll get rid of those bullets. But
Yeah, I was gonna number.
You and
can do
I
numbers.
have to talk about a policy template.
oh, I know we've been talking about it for 3 years, girl. Don't even get me started.
Yeah. Well, but because it needs to be accessible.
So maybe we can look into
Right.
AI and have AI create some policy templates for
Honestly,
us.
I'm not even kidding you, Barb. I inserted our policies from the last 10 years. I picked a random sample, put it in ChatGPT, and said, build me the style guide for policy based on what we've done, and it generated one in literally 0.3 seconds.
No.
So
Gotta make sure it's not
yeah.
a deep fake.
Exactly.
Yeah. How long is it going to take us all to be like stupid?
Right. We just like don't move.
Yeah, right. Like we,
Don't
Yeah.
blink. So it's possible that AI could be helpful in creating template style guide for us. It's just something I did on my own to see, there's what I like in formatting, but then what is it really worth it to recreate formatting for 1,000 pages when we should just be adhering to what is most commonly used and accessible in the policies? So worth a conversation. So, all right, there is nothing else on the agenda. Does anybody else have anything to bring forward? KFA, anything from you?
I think we're good.
We gave you plenty to do.
You did. I think I'll use AI to clean up whistleblower.
Go for it. Fantastic. Well, with that, I will take a motion to adjourn.
So moved.
Moved by Barb Higgins.
Seconded.
Seconded by Sarah Sadowski. All in favor?
Aye.
We are adjourned at 6:38.